Hello, good afternoon. For those of you that are in Tokyo, like myself, I'm today with my good friends at Shiga here in Tokyo, and of course, good morning for all of you that are in Europe listening to us, including our speaker of today, one of the two speakers, Anne Butarik. Anne, very nice to see you, and welcome and good morning.
Thanks, Luca. Konnichiwa, and very nice to see you.
Thank you. I'll get back to you in a second. I would like just to introduce myself very quickly. My name is Luca Escoffier, and I work here in Tokyo at the EU-Japan Center for Industrial Cooperation, joint venture between METI and the European Commission. And I run the Technology Transfer Help Desk. It's a service of the center that has the intention and desire to put in touch academia, research institutions with SMEs, small and medium-sized enterprises, with large corporations, and help inventors, and basically facilitate connections among people that and companies that do want to make a technology and turn it into an innovation. So the purpose of the help desk is to see innovations come to light, to come to existence. So I'm very happy to be with you today. I have been working with Shiga for quite some time now. We have organized other events with other initiatives going on. So I'm very excited to be with you today to start this webinar and basically giving the opening remarks and closing remarks. Today's first speaker will be Anne, that we just saw and listened to for a second. But let me tell you who is Anne. Anne is the chairwoman of the SPC group within the French Patent Attorneys Organization, CPI, and she's also French, a European patent attorney, graduated in chemistry and IP law, and is the partner of the Life Science Department of Remdesivir, one of the top 5 French IP law firms that she joined in 2002. With the Remdesivir teams, she's advising French and foreign companies, of course, including startups, universities, medium-sized companies, international corporations. She's involved on a regular basis in patent and supplemental protection certificate litigations in pharma, including French disputes conducted in parallel with other pan-European litigations. With the Remdesivir, she is in charge of filing and prosecuting all the SPCs in the chemistry field, and she has developed a large experience in this field. She closely follows legislative and jurisprudential developments of SPC system, whose optimization is one of the top priorities of the EU Commission. Before giving the floor to Anne, I would also remind the audience that we will make circulate a survey at the end of the event. We will have a recording of of today's presentations that will be also shared. And that's pretty much it. So I would give the floor to our first speaker, and the floor is yours.
Thanks a lot, Luca. I'm sharing my screen. So normally you can share my screen.
Perfect.
Konnichiwa. I am honored to be with you today, and I would like to thank you, Luca, for this presentation and for the organization of the webinar. I would also like to thank the whole Shiga team, and especially Ida-san, for the invitation and for the whole organization. Today, I would like to present you the current trends in SPCs in Europe. SPCs stand for Supplementary Protection Certificates. For now, the SPC system has been identified as a key system within Europe for pharma by EU Commission. The EU Commission is now looking for further optimization of the SPC system now and in the near future. SPCs are IP rights that may extend by up to 5.5 years the protection conferred by a patent on a medicinal product. The SPC regime is defined at the EU level. All European countries provide for SPC protection on the basis of a common EU regulation, the regulation number 469/2009. EU countries are the blue one and Croatia the yellow one. Switzerland and Norway have adopted national law very similar. One may also say almost identical to the EU regulation, as UK will do after Brexit. The interpretation of the EU regulation is performed by the European Court of Justice, and there are always new questions for that court. I will today present you two recent decisions of the European Court of Justice, which are of high relevance for the SPC system and which shall now close questions on the interpretation of Article 3 of that regulation, questions which were opened some years ago by the European Court of Justice itself. Article 3 is a crucial article of the regulation which defines the conditions for obtaining a SPC. A certificate shall be granted if A, the product is protected by a basic patent in force, B, a valid authorization to place the product on the market as a medicinal product has been granted, C, the product has not already been the subject of a certificate, and D, the authorization referred to in point B is the first authorization. Article 3E thus requires that the product is protected by the basic patent. What does that mean? Several decisions have been issued by the European Court of Justice in the past 10 years on the interpretation of that article. But these decisions did not provide for a clear answer, and in fact, these decisions raised more questions due notably to variation in the proposed definition and implementation of criteria which were in fact difficult to reconcile. Now the European Court of Justice clarified the interpretation of Article 3E and gives an answer which we hope may be definitive. The case was specific to combination products, but the rules defined in that decision for determining whether a product is protected by a basic patent will be universal and shared for a single product or for a combination. The rules are now the following. The claims shall relate necessarily and specifically to the product, meaning that for a person skilled in the art and on the basis of the prior art at the filing date or priority date of the basic patent, the product must necessarily, in the light of the description and drawings of that patent, fall under the invention covered by that patent, and the product or each of the active ingredients of the combination must be specifically identifiable in the light of all the information disclosed by that patent. Another relevant part of Article 3 is the subparagraph D, stating that the marketing authorization on which the SPC shall be based is the first authorization. Some years ago, a decision of the European Court of Justice generated a lot of confusion. This decision is known as the NORIM decision. In that case, a SPC application was based on a marketing authorization for medical use of melatonin for treating human disorder. The Patent Office refused to grant that application in view of the earlier marketing authorization for veterinary use of melatonin. That refusal was coherent with the literal interpretation of the regulation and with the previous case law of the European Court of Justice. Surprisingly, in NORIM, the European Court of Justice decided that a SPC could nevertheless be granted, and that a SPC could be granted for the same active substance on the basis of a second marketing authorization if new indication of the second marketing authorization is covered by the basic second medical use patent. But the European Court of Justice did not define the terms second medical use. Shall this approach be allowed only for real new indication, especially only for cases like this one, where you have a first veterinarian medical use, medical authorization versus a human marketing authorization? Or can this approach be extended to all new indication, including new dosage, new excipients, new formulation, and so on? NORIM generated a lot of confusion. Recently, a new case similar to the NORIM one, but dealing here with two marketing authorizations for human use, was refused by the French Patent Office, and the Paris Court referred the case to the Court of Justice. In that case, the first marketing authorization was for cyclosporine to prevent graft rejection, and the second marketing authorization quoted in the SPC request was for cyclosporine for treating severe keratitis, so an ophthalmic use. The French Patent Office refused the SPC application, considering that the applicant did not demonstrate that the second marketing authorization was a new therapeutic indication within the meaning of NORIM, and further considered that the basic patent was not limited to severe keratosis indication. In his referral, the Paris Court thus requested guidelines for interpreting the terms different application of an old active substance as understood in NOIM, and further asked whether the scope of the second marketing authorization and the scope of the second medical use shall be identical. The European Court of Justice answered as follows. First, the court considers that Article 3D refers to the term product. According to Article 1B of the regulation and to the case law of the European Court of Justice, a product is an active substance, and an active substance is a substance with therapeutic effect of its own. There is no reference in Article 1B or in the case law for the definition of product to a specific medical use, bearing furthermore in mind that pursuant to Article 4 of that regulation, the protection conferred by a SPC extends to any authorized medical use at the filing date, at second date, and later. The Court of Justice concluded that an active substance in a new use shall not and cannot define a distinct product. The Court of Justice then analyzed whether, as in NOIM, one can consider that a marketing authorization for a new medical use can be considered as the first marketing authorization when that medical use has been claimed in a second medical use patent. The Court of Justice considered that Article 3D does not refer to the basic patent. Article 3D only refers to the product, and as discussed previously, the product is the active substance, whatever the medical use. So, the court considered that the first marketing authorization pursuant to Article 3D is the first medical marketing authorization for the product, and this analysis does not depend and shall not depend on the medical use. Thus, the Court of Justice decided that Article 3D of the regulation must be interpreted as meaning that a marketing authorization cannot be considered to be the first marketing authorization where it covers a new therapeutic application of an active ingredient or of a combination of active ingredient, and that active ingredient or combination has already been the subject of a marketing authorization for a different therapeutic application. Thus, NOIM has been reversed. These two recent decisions are of high importance. They have both been issued by the Grand Chamber, which is the extended formation of the court, Accordingly, their decisions have prevalence above all other decisions of the European Court of Justice. And till these two decisions, all other past decisions of the European Court of Justice in the SPC field were all rendered by the court in its normal formation. The objective of attributing these two cases to the Grand Chamber was to definitively settle the discussion on interpretation of Article 3E and Article 3D of the regulation. The Court of Justice of European Court of Justice now rolled back to a strict interpretation of the regulation, meaning that one person can obtain one SPC and only one SPC for each active substance. That's the new rule that the applicants have to consider now, and applicants should adapt their strategy in consequence. I will now present you a recent amendment to the regulation. For your information, the EU Commission started in 2018 an intensive review of the EU legislative instruments and related incentives in the pharmaceutical field, including a review of the SPC system. The Commission wants to perform an evidence-based analysis of the impact of these law incentives and that SPC system on the marketing of innovative medicinal products and of generic products. Studies are still ongoing. In the IP Action Plan published last week by the EU Commission, the Commission informed that she wants to optimize the SPC system to make it more transparent and more efficient. The objective is to achieve that goal for 2022. I'm sorry. The introduction is in the law of the SPC manufacturing waiver that I will present you today is a direct consequence of the reviewal work initiated by the Commission. In 2019, a new regulation, the regulation number 933/2019, was adopted. That regulation amends the current regulation 469/2009 and entered into force on 1st July 2019. According to that new regulation, third party can now, once the patent is expired and during the whole duration of the SPC, manufacture in Europe the medicinal product protected by that SPC for the exclusive purpose of export to countries outside Europe. In addition to that, up to 6 months prior to the SPC expiry, third party can manufacture in Europe and stockpile the medicinal product in Europe for the purpose to launch generics on the European market at day one. These waivers encompass all ancillary activities which are strictly necessary for making and exporting the product. For example, a third party can manufacture the active ingredient of the drug, and another third party can formulate the drug. That figure makes a representation of the situation according to the formal law and to the amending law. On the top of that figure, it was a situation pursuant to the formal law. At the expiration date of the patent, when you have a SPC, third party have to wait for the expiration date of the SPC to start any manufacturing activity. Now, with that law, when the patent is expired, even if a SPC is granted, third party can start manufacturing in Europe the medicinal product with solely and exclusively aim at exporting that medicinal product to non-EU countries. In addition to that, 6 months before the expiration date of the SPC, third party can start manufacturing and stockpiling in Europe with, in that case, the objective to launch the generic drug as soon as the SPC expires. It is what they call the D1 launch of generic in Europe. Some formal requirements are linked to that new law. The third party has the obligation to notify the National Patent Office for publication and the SPC with the name and address of the maker, indication that making is for export and or storing, EU state where the product is to be made and or stored, of course, information on the relevant SPC in the UA for publication by the Patent Office for information purpose, and also for exportation to third countries, the number of the marketing authorization in each country of export. The aim here is to give enough information to SPC holder so that he can check that the product is effectively only for exportation and that the export product will not come back in Europe. That also why the product manufacturing under that new law shall be marked with the EU export logo to be sure that they cannot come back in Europe. Then the third party requiring for that manufacturing waiver has the obligation to inform all contractors that will be involved that acts other than those covered by the waiver may infringe the SPC. That's all for today. I thank you for your attention. Arigato gozaimashita.
Thank you, Anne, for your contribution. Very, very clear. We learn a lot. Personally, I learn a lot. So hopefully most of the people in the audience learn many things, new things. Hello and welcome back. It's 6:35 p.m. JST, 10:35 a.m. if you're in Europe. We can start with the second presentation for today from Dr. Masato Ida. And before giving the floor to him, let me maybe introduce him for a minute or two. Dr. Masato Ida is the Vice President here at Shiga International Patent Office. He has an extensive experience in handling patent prosecution in the field of biotechnology, pharmaceuticals, on behalf of pharmaceutical companies, universities, research institutions, and has over 7 years of experience as a Japanese patent attorney. His experience and expertise cover patent prosecution, trials for invalidation, suits against trial decisions. He has been giving lectures on biotechnologies and pharmaceuticals at foreign IP organizations such as the RIPLA, the Rochester Intellectual Property Law Association, CLA, California Lawyers Association, and so on. He has also been asked to contribute articles to medical magazines based on his wide knowledge and experience in both biotechnology and the IP field. In 2020, he was also selected for IAM Patent 1000 in 2020, so the world's leading patent professionals of intellectual asset management. Without further ado, I will give the floor to Dr. Ida, please.
So thank you, Luca, for your presentation, for your introduction for me. And hello, everyone. Nice to meet you. And thank you for joining this seminar. I'm honored to make a presentation in front of you. And I'm sorry I'm wearing a mask because I'm now in the meeting room of my office. And you know, we have a severe situation because of COVID-19. And I hope you keep safe and healthy. And let's start my presentation. The title of my presentation is COVID-19-related patents. These are contents. Firstly, I'll talk about COVID-19-related patents. Precisely, overview of COVID-19-related drug, vaccine-related patents, and small compound-related patents. Next, I'm going to talk about comparison of patent term extension and SPC. Precisely, first, I want to explain the basic rule of PTE, and next, I'd like to focus on the different points between PTE and SPC. Let's move on to overview of COVID-19-related drug. Firstly, what is COVID-19? COVID-19 is infection disease caused by SARS-CoV-2. CO stands for corona, VI stands for virus, D stands for disease. 19 is first discovered in 2019. And SARS-CoV-2, it's so-called new type coronavirus in Japan. It's a member of Coronaviridae and classified as a single-strand RNA virus. Regarding SARS, you know, it's severe acute respiratory syndrome. And I'd like to briefly explain the structure of SARS-CoV-2. This coronavirus has spike protein outside and RNA gene inside. And using this spike protein, it attaches to to the receptor of the human cell. And through this receptor, this virus enter into the human body. And how are we gonna defeat SARS-CoV-2? These are two strategies. One strategy is vaccine. At least we have two types of vaccine. One is this spike protein. We only express spike protein in the human body as immunogen. Or we use inactivated virus. We inactivated this coronavirus by X-ray or something, and the RNA gene in this virus is disrupted not to adversely affect the human body. And if we inject these vaccines into the human body, antibodies against SARS-CoV-2 will be induced like this. And second strategy is using small compound. At least we have two promising small compounds like Avigan and Remdesivir. This is a brief drawing of the mechanism of these compounds. In the coronavirus, there is a RNA polymerase. It functions to replicate RNA gene, and these compounds inhibit this enzyme. Now, let's move on to vaccine-related patents. As you know, there are several promising vaccines now, and this product, AZD1222, is one of them. This is a viral vector vaccine, and patentee is Oxford University. And this product is being co-developed by Oxford University and AstraZeneca. And this name, ChAd-OX1, it stands for chimpanzee adenovirus OXOD1. This is a vector as shown here. And we'd like to briefly show the scheme of the production of vaccine. Using this adenovirus vector, full-length spike protein of SARS-CoV-2 encoding gene is integrated as shown here. And using this vector, vaccine is produced. And if we inject this vaccine into the human body, spike protein is produced. And then antibody is induced. This is a corresponding patent in Japan. Claim 1 is adenovirus vector comprising a capsid, wherein the capsid contains one or more capsid protein derived from wild-type chimpanzee adenovirus, ADY25, and capsidates a nucleic acid molecule comprising an exogenous nucleotide sequence of interest, operably linked to expression control sequences, which directs the translation, transcription, and/or expression thereof in an animal cell. And the adenoviral packaging signal sequence, where nucleotide sequence coding the wild-type chimpanzee adenovirus ADY25 is sequence number 1. looking at this claim, and there is no limitation in the claims to the antigen of SARS-CoV-2. You can see these red characters. Any gene of interest, you can use it in this. This patentee can use any of interest gene in this claim. So any adenovirus vector comprising one of a capsid derived from wild-type chimpanzee adenovirus ADY25 would be within the claim scope. On the other hand, if you want to make the vaccine using another vector, it's totally out of claim scope. And next, we'd like to move on to small compound-related patents. First, Remdesivir. Patentee, Gilead Sciences. Remdesivir is a small molecule which is a prodrug that is converted in the body into a nucleotide analog and is used for treatment of the Ebola virus disease. Chemical structure is shown here. And this is a corresponding patent in Japan. Claim 23. The compound of claim 20 that is this formula or a pharmaceutical acceptable salt thereof. This claim is just a compound claim which does not specify any usage. And they have another patent application, and it's still pending. Amended claim 36 is a composition for treating a coronaviridae infection in a human in need thereof, comprising a compound having the following structure. This or a pharmaceutical acceptable salt thereof. This claim is a composition claim for treating a coronaviridae infection. It includes the treating a coronavirus infection. And in the example of this specification, MERS-CoV and SARS-CoV antiviral activities are shown. So I think originally this invention was for the treatment of these coronavirus. So other than this current new coronavirus. And this is the legal status of Remdesivir related patent family. As you can see, based on US patent, all the family members are still active. Next, we'd like to move on to Avigan. Avigan, Favipiravir. The patentee is Fujifilm Toyama Chemical. Avigan, it's a small molecule which is a viral RNA-dependent RNA polymerase inhibitor and used for treatment of influenza. Chemical structure is shown here. And this is a corresponding JP patent. Claim 1 is an antiviral agent comprising of nitrogen containing heterocyclic carboxamide derivative represented by the following general formula, wherein ring A represents a substituted or unsubstituted pyrazine, pyrimidine, pyridazine, or triazine ring. R1 represents OH. R2 represents a hydrogen atom. And the block line represents a single bond or a salt thereof. This claim is an agent claim, which specifies its usage but the claim scope is very broad. In the scope, ring A is broad. Just looking at the structure of Avigan, definitely this general formula covers Avigan compound. And this claim covers the anti-new coronaviral agent. But in this point, I'll explain later. And claim 6, a nitrogen containing heterocycle derivative represented by the following general formula. Formula is here, wherein ring A prime represents a pyrazine ring, substitute with a halogen atom. R1 represents OH, R2 represents a hydrogen atom, and the broken line represents a single bond or a salt thereof. This claim is a compound claim which does not specify any usage. And this is a legal status of Avigan-related patent family. Unfortunately, most of the family members are expired, and only the extended patent right in Japan is active. And next, you'd like to explain this precisely. This is the information of PTE application of Avigan-related patent. Application number, filing date, grant date, extension term, it's 5 years. And regarding the contents of disposition designated by cabinet order under Japanese patent law. Subject of the disposition, product name, Avigan tablet 200 mg. Active ingredient, Favipiravir. And this is the key point. Specific usage of the product prescribed by the disposition. It's novel or re-emerging influenza. Limited only to cases where other influenza antiviral medicines are found to be ineffective or insufficiently effective. Here, we'd like to explain the scope of extended patent in Japan. According to Japanese patent law, the scope of an extended Japanese patent is limited by a product and the specific use of the product. Product means it's defined by active pharmaceutical ingredient. And the use is defined by target disease, dosage, and usage. So in terms of Japanese patent right, regarding this Avigan case, the scope of extended patent is only the use of the product for treating influenza virus infection. It means the treating new coronavirus infection, it's out of claim scope. And here, we'd like to a little bit compare these compounds. And just looking at these compounds and ribonucleotide, it's kind of material of RNA gene. And regarding the remdesivir, the part of this compound is similar to that of purine. And regarding Avigan, this part is similar to that of pyrimidine. So it means these compounds function as ribonucleotide analogs. This is a brief mechanism. As I explained you, and so this is a RNA polymerase. It's enzyme in coronavirus. and it replicates RNA gene. But using these compounds, it inhibits this function of RNA polymerase in a competitive manner with RNA nucleotide. Sorry, and which is more potent? I'm sorry, I don't know, but I hope these compounds collaboratively help us. And regarding patent right, Remdesivir, it's still active, and Avigan only active in the treating influenza virus infection. And we'd like to move on to comparison of PTE and SPC. Firstly, I'd like to talk about the basic rule of patent term extension. These are requirements for PTE. The patented invention must relate to pharmaceuticals. And we need the fact that marketing approval was given by the Japanese regulatory authority to a patentee or a licensee for a specific pharmaceutical product. And we also need the fact that there was a period of time in which the implementation, for example, the sales of product, import of product, something like that, of the patented invention was not possible. And regarding the PT application, applicant, it's patented only. And we have time limits for filing PT applications. We have to meet these two criteria. And this is a time frame of the original patent application. First, within 3 months from receiving approval by the Japanese regulatory authority for marketing a special pharmaceutical product. So we have to file it within 3 months in this stage. And also, we have to do that by the end of the original patent term of the patent to be extended. So by the end of here. And PT period. It's a period of time in which the implementation of a patented invention was not possible. Maximum extension is 5 years. And PT period must be the shorter of the following two periods. A, from the registration of the patent to the marketing approval by the Japanese regulatory authority. B, from the start of clinical trials to the marketing approval by the Japanese regulatory authority. I'll show you precisely in the next slide. In case 1, if the registration patent is between start of clinical trial and marketing approval, PTO period is shown here. In case 2, if the start of clinical trial is between registration of patent and marketing approval, PT period is here. And this is an examination guideline for PTE. Marketing of a newly approved product must be within the scope of production of a patent to be extended. And there is no prior marketing approval which covers the marketing of the newly approved product. And here, we are going to the example. Claim is compound A. Pre-marketing approval, API, compound A1. It's within the scope of compound A. Use liver cancer. Dosage usage 5 mg once per day. And new marketing approval, API, compound A1. It's also within the scope of the compound A. And use its pain relief. And I want to ask you a question. Based on new marketing approval, do you think PT is approval or not approval? So please raise your hand. Do you think approval? I can see you precisely. Oh, 80%. Or not approval? Someone is raising a hand. Thank you so much. And not approval, 20%. The answer is yes, PT is allowable. Pre-marketing approval cannot cover the marketing of the newly approved product because the approved use in pre-marketing it's liver cancer, so it's not a pain relief. So this point, because of the difference of this point. And next example, claim is a pain relief agent comprising compound A. Pre-marketing approval, API, compound A2, it's within the scope of compound A. Use, it's pain relief, dosage usage, 5 mg once per day. And new marketing approval, API, compound A1, it's also within the scope of compound A. And use and dosage, it's the same of the pre-marketing. So next question, based on this new marketing approval, do you think PT is allowable or not allowable? The answer, it's allowable. Pre-marketing approval cannot cover the marketing of the newly approved product because the API in pre-marketing approval was not compound A1 but A2. And these are the example of the inventions for which a patent PT is available or not available. Regarding available, compound claims, combination claims, combustion claim, new use of compound claim, method of preparing compound claim are also available for application of PT. And not available, intermediates, catalysts, and apparatus use of preparing compound, it's not available. And we'd like to quickly move on to comparison of PTE and SPC. We just focus on the different point. Regarding the number of PTE extensions, regarding the number of possible extensions per one patent, in JP, we can do it multiple times, depending on times of regulatory approval. In EP, it's only once. And regarding the number of patents that can be extended by one regulatory approval, in JP, no limit. In EP, only one patent right selected by the patentee. We'll show you precisely two features. One feature, if multiple patents exist, two or more PTEs are possible by filing multiple PT applications, even though only one marketing approval has been given. This is an example. We have one marketing approval. It's related to a product, including compound X for treating hypertension. And we have two patents. One is related to compound claim covering compound X. And second is a method claim covering the method for preparing the compound X. these two patents are extendable. We'd like to summarize this feature. In each patent, we can obtain each PTE. Next feature, if multiple marketing approvals exist, 2 or more PTEs are possible by filing multiple PTE applications, even for a single patent. This is an example. We have 2 marketing approvals. One is used for use of a specific product comprising compound X for treating disease Y. And second is for treating disease G. And we have one patent related to compound claim covering X. This patent is extendable by filing 2 PTE applications based on these 2 marketing approvals. So this is a summary of this feature. Regarding the PTE, we can obtain 4 years PTE for treating disease Y and 5 years PTE for treating disease D. This is the end of my presentation. Now we are suffering from coronavirus, but as you know, we have promising drugs. And now let's bring together the world's wisdom and defeat coronavirus. By doing that, coronavirus will say, "I'll never be back. Hasta la vista, baby." Thank you for my presentation, and hopefully we'd like to see you in person next year. Thank you.
Thank you, Ida-san, for the presentation, especially the last slide. We all, yes, think and hope they will never get back. I would like also to thank once again Anne, that from the beginning stayed with us with a very insightful presentation, and of course all of you present. I would like to spend also other 20 seconds to remind you that we will be sending you shortly a form with a survey, and also we will share in the following days the video of the recording. I can see also Anne in the video, so we can say hi and goodbye. And once again, thanks for being with us today, and hopefully I'll see you soon. Bye-bye.